Hello, we are Mia Neidhardt and Cindy Drake, and we're going to share some of our findings from our audit of protection orders in King County Superior Court. Before we get started, I just wanted to give a little bit of background on the topic. Harassment, stalking, domestic violence, sexual assault, and other types of abuse are prevalent in society. An estimated 1 in 3 women and 1 in 4 men across the United States have experienced some form of physical violence by an intimate partner. In King County, domestic violence homicides were more than twice as high in 2020 and 2021 compared to the rates for the prior 4 years. Research has shown that protection orders can be effective tools to help keep people safe from interpersonal violence and harassment when the protection order process is responsive to user needs and coordinates the issuing, serving, and enforcing of orders. To give a summary of what we'll be sharing today, I'm going to start by sharing some background information about the process to obtain a protection order and share some of the disparate outcomes identified in our audit. And then Cindy will discuss barriers to access for those seeking an order or responding to an order, and touch on the need for increased collaboration and user-focused continual improvement. Our audit focused on civil protection orders in King County Superior Court, and these are civil rather than criminal legal proceedings. There are 6 types of civil orders that can be petitioned for in Washington State. As you can see here in orange, the majority of orders filed for in King County Superior Court were domestic violence orders, with an average of nearly 3,000 petitions per year. Civil protection orders are intended to be accessible to self-represented participants, meaning that they would not need an attorney to represent them. For most types of orders, these participants are the petitioner, the person seeking protection, and the respondent, the person they are seeking protection from. However, the process is not always straightforward, and it can be complicated to navigate without assistance. You don't need to focus on all the details here of this process overview, but it shows a summary of the steps generally needed to obtain an order. The process generally involves at least 2 hearings. At the first, called an ex parte hearing, because the respondent is not present, a commissioner can grant a temporary order, which is an emergency order in place until a full hearing can be held with the respondent, usually 2 weeks later. And at the full hearing, the commissioner may grant a full protection order, which is usually good for 1 year. The process can be delayed with continuances if the respondent has not been served with the necessary documents in time for a full hearing, or for several other reasons. If there are continuances, the petitioner will typically be granted consecutive temporary orders and will have to reappear at hearings every 2 weeks. If the petitioner does not attend a hearing, the commissioner often has the discretion to dismiss the case. Academic research has found that protection orders are effective in reducing incidents of violence reported to the police. However, this research has also found that this positive relationship found for full protection orders did not extend to temporary orders, indicating that a petitioner may not find the same level of safety if they only obtain a temporary order. From 2016 to mid-2021, 78% of petitioners in Superior Court obtained a temporary order, but only 35% obtained a full order. And some petitioners were more likely than others to obtain an order. Although the process was developed with the intention that an attorney not be needed, a minority of participants did have an attorney represent them. And of these petitioners with an attorney, 56% received a full order, compared with 34% of those who were self-represented. This difference was statistically significant after controlling for factors like type of order. Some petitioners may have an advocate's assistance instead of an attorney. For example, some community organizations provide advocacy for petitioners of certain types of orders. Also, the prosecuting attorney's office houses a program to provide advocacy services for petitioners seeking domestic violence orders against an intimate partner. Given resource limitations, though, they cannot provide this service to all petitioners. When looking at just domestic violence petitioners, 51% of petitioners with advocacy support received a full order, compared with 35% of those without an advocate. This difference was also statistically significant. And Cindy is going to talk a bit more about the challenges for participants without an attorney or advocate in a minute. But we also found disparities based on race. Based on self-reported demographic data, Indian American and Black petitioners were the least likely to receive full protection orders. Now, this data raises a lot of questions, and more analysis is needed to get at some of the answers. And in order to do so, we recommended that Superior Court track more detailed information about outcomes. For example, data on the reasons why orders might be denied or dismissed, and use the data analysis to inform efforts to improve processes and address disparities.
So I'm going to start off by discussing two key barriers to access. First, we found there's too little assistance for participants who are trying to manage the process on their own. And second, we identified limited language support for participants who do not speak English. And then I'll wrap up by talking about the need for ongoing process improvement that is focused on the user's perspective and is collaborative with key stakeholders, such as law enforcement and advocates. The first barrier is that there isn't enough personalized support available for individuals who want help with the protection order process. As Mia mentioned, petitioners who have assistance from an attorney or advocate are more likely to obtain a full order than those who do not. And we saw this result in our analysis of court data, and we also observed directly how attorneys and advocates can explain the details of the process and can ensure that forms are completed correctly and that documentation includes the elements necessary to meet the standard of evidence. We also saw how attorneys and advocates can reduce the impact of language and technology challenges by providing translation and technical assistance. However, most petitioners do not receive detailed personalized assistance with either filing for an order or preparing for the hearings. Without assistance from an attorney or an advocate, participants can contact the Superior Court Clerk's Office for help, but due to workload and also legal constraints, assistance from the clerk's office is really limited to answering process questions. And this means that most participants are really trying to represent themselves in a legal process that is complicated, can be intimidating, and also brings both language and technical challenges. Given the limited county resources available for participants, we recommend the development and implementation of a plan to increase resources for self-represented individuals. And in best practices, there are both advocacy and help desk models that could be used to help fill this gap. Another key barrier is limited language support for petitioners and respondents who do not speak English. Superior Court provides interpreters to participants during the hearings themselves, but there's very limited support throughout the rest of the process. There isn't language support for individuals when they are first entering a Zoom hearing before the hearing actually begins to help participants get to the right virtual room or to help with any technical difficulties. The petitions and other required forms must be completed in English. Some instructions and a lot of information on the county's websites are available in English only. And the orders themselves are available only in English. So someone at the receiving end of a protection order who does not speak or read English may not be able to read and understand what the order says without getting additional assistance. Since orders are enforceable by arrest, this can obviously have an impact on individuals who don't read English. To address these issues, we recommend that Superior Court update its language access plan to address the language support needs of participants in the protection order process. And this should include increasing support in some key areas, such as ensuring key forms and instructions are available in other languages, making available some sort of technical support during the virtual hearings, and communicating language access options so that petitioners and respondents are aware of the assistance available to them. One option for this is including a language notice on forms or during the virtual hearings that lets the reader or their participant know in a variety of languages how they can request language assistance with the process. In addition to making recommendations to address specific barriers, we also recommend that Superior Court take steps to ensure ongoing continual improvement to the protection order processes. We saw many individuals and stakeholder agencies and in the courts who are trying to improve processes and to reduce barriers. And we were told that there have been recent improvements in collaboration between the courts and others over the past year. But we were also told by stakeholders about challenges in achieving lasting improvements that could make the process more efficient for the county and improve access for participants. And a lot of what was reported is that it can be challenging to identify and collaborate with individuals in the courts who have the authority to make system improvements. We understand that the courts are struggling with extremely high workload right now, and there can be other reasons why systemic improvements are challenging. But we also want to emphasize that barriers to access result in additional hearings and the reissuance of temporary orders, both of which can multiply workload for the courts, the clerk's office, and law enforcement, in addition to creating delays and barriers for petitioners and respondents. Currently, there isn't a court-led effort, such as a working group, to facilitate accountability and collaboration for ongoing improvement. And related to this, there isn't a coordinated strategy to capture user feedback about processes and to use it to identify improvements. Several entities collect pieces of user feedback, but these efforts are not comprehensive, and there isn't a court entity collecting all of this information and using it to make improvements. To address these issues, we're recommending that Superior Court create a work group or another sort of entity with the authority and accountability for continuous improvement. The same entity should collaborate with stakeholders to identify user challenges and improve processes to meet user needs as much as possible. This entity should also facilitate and ensure the effective implementation of elements of the new state legislation that must be implemented by the county. To summarize, we found that protection order processes are complicated and participants are often navigating the process on their own. We identified disparate outcomes by race, and we identified barriers that will remain without improvements beyond changes that are required by statewide reform. We also identified the need for collaborative and user-focused continual improvement. That concludes our presentation, and the full report can be found on our website.